Hello, everyone. Today we have an eminent guest with us, an IT veteran and a seasoned professional who simply needs no introduction. Yes, we have with us Mr. N.A. Vijayashankar Nagarajarao, who is popularly known as Mr. Naavi, and he is one of the pioneer in the field of cyber law in India and is also a pioneer in data protection and data governance. Mr. Rao is the founder of Naavi Organization and Cyber Law College. He's also the chairman of the Foundation of Data Protection Professionals in India, that is FDPPI, the premier organization in India dedicated to data protection. Mr. Naavi has also pioneered many cyber law related technology services such as Cyber Evidence Archival Center and online dispute resolution. So clearly, he's one of those veterans who needs no introduction. And today he's going to talk about, the DPDP Act that has been introduced in India and how is it going to impact the businesses. So without wasting any more time, I would like to straight away get into a quick chat with Mr. Naavi. Good morning, sir. We are going to be, the first thing that I want to understand from you is, what are some of your key takeaways and concerns regarding the DPDP Act that has been introduced by the Indian government?
See, first of all, we should appreciate that after 5 years of effort since around 2018, we have been able to come up with a draft of a legislation, which has been presently approved by the Parliament and the President, but still we are waiting for a notification, which means that the government still has some kind of a hesitation or lack of confidence in making this act applicable. Basically, the idea was that Section 43 capital A of Information Technology Act was insufficient to protect the personal data the way international laws like GDPR protected, and therefore this particular act has been brought into place. So it is something which we should all welcome. Okay. Now, it actually tries to provide the consent as a major component of establishing the legal basis, which is the right way to go. Because the very definition of a right of privacy is to give a right of choice to the data principle, and therefore nothing other than the consent could actually hold this right to privacy under this law. Of course, practicality requires legitimate use, so there has been a legitimate use provision. There is also the exemptions which are available for national security reasons. So I feel it is a good attempt that way. There has been a definition of a significant data fiduciary, which actually will have more responsibilities, including the mandatory provision of designating a DPO and appointing an external independent data auditor. This is one of the biggest reforms or say points to be noted in this particular law as compared to the other international laws. So I feel that we are ready for a good way forward for this data protection. Of course, it does say that this is applicable only for digital personal data, which means that it does not try to address the paper form of personal data, which an organization may collect. But I think it is a minor thing which can, where the risk is actually something different from the risk of collecting and processing of digital personal data. Applicability is restricted to the data which is generated from India, and there has been concession given to the processing of personal data in India in case that data is not of Indians but of let us say some other origin like the EU origin. Therefore, this act clearly provides some kind of an exception for data processors who process the personal data of EU region as a part of a data controller, data processor contract. So I think this is a very innovative step the government has taken, we will welcome it. As far as the concerns are concerned, say, we will always have concerns. It is not that the law will be perfect, and particularly when the government does come up with a law which is not widely consulted as may be required, or consulted within a small group of people who have, say, some kind of vested interests of their own, there is going to be some areas of concern. We also have that kind of concern, but we hope we will be able to address those concerns as we go forward.
Right, right. So you
Yeah.
talked about data privacy, you talked about data principle, and then you also highlighted a few concerns regarding the DPDPA Act that has been rolled out. But when it comes down to organizations, what organizations really, how can they really comply with the DPDPA Act, and what do they really need to do differently from here on?
So the first thing the organization should realize is being compliant with a law like DPDPA is different from being compliant with the kind of compliances they have been presently dealing with, like an ISO 27001 compliance or something like that. So many organizations do not have clarity on what it means to be compliant with a law versus being compliant with the requirement of business kind of a thing, which is a best practice guideline. Here, the concern they should remember is that the non-compliance could lead to reasonably heavy fines. Say 250 crores plus is a heavy penalty in the Indian circumstances, but many of the MNCs are aware that GDPR has penalties running to thousands of crores of rupees. For them, this 250 crores is really not big. But one thing which the organizations should realize is there is a difference between penalty for a data breach and a penalty for non-compliance not amounting to data breach. Like in criminal laws, we have intentions amounting to, say, murder or not amounting to murder. We have now to create a distinction that there could be penalties levied even when there is no data breach, because a certain compliance was not done properly, legal basis was not established, notice was not properly given, consent was not taken, DPO was not appointed. This kind of things could be considered as reasons for penalty, though Indian Data Protection Board is likely to be very liberal, at least for the next few years, on such non-compliances without a data breach. Of course, if there is a data breach, obviously there is a public interest involved, so the Data Protection Board has to take it seriously and impose penalties. Therefore, the organizations need to put in place a proper system of compliance for all aspects of the act, whether that leads to data breach or does not lead to data breach. In this aspect, they have to take a new view of what they presently call as data privacy. See, when people talk of data privacy, they normally talk of preserving the confidentiality, integrity, and availability of data. In the privacy scenario, they say personal data. Okay, so earlier information security, we were talking of the entire data. Now we are talking of personal data. But DPDPA compliance goes beyond this protecting the personal information from unauthorized access, modification kind of a thing, but also establishing a legal basis. This is the most critical aspect of compliance. A notice has to be given to a data principal before collecting the information. Consent has to be obtained, which means an acceptance has to be obtained. And if you take it as a click wrap contract, the question of whether click wrap contract is acceptable under Information Technology Act will come into being. So compliance requires adoption of methods which are compliant with the Act and also with ITA 2000 provisions. There are 2 or 3 areas where there is a clash between DPDPA and the ITA 2000. For example, this signing of a consent form, like I accept kind of a thing, which people do. This is not acceptable as an authentication or a contractual acceptance under Information Technology Act. There has to be a digital signature or a e-sign. Now, without going in for a e-sign, is there a possibility of obtaining consent which is legally acceptable is one of the challenges which the organizations will be facing. Second, there is no personal remedy to data principles under this act. So if there is a complaint, the Data Protection Board will provide for penalties, but the data principal, if you expects some kind of a compensation, he will invoke Information Technology Act, the adjudicator under that act. Therefore, the data fiduciaries need to deal with both the Data Protection Board as well as the adjudicator of Information Technology Act. Similarly, when we come to data fiduciary and data processor contractual, say, some kind of disagreements, the disputes need to be settled under Section 72 capital A of ITA 2000 in certain cases where personal data is involved, where there can be again a need to go for the adjudicator, and there is a penalty of up to 25 lakhs. So there are many such, and even the data breach notification will have to be given even to the certain director. So, and renewal of privacy policy, there is some requirement under ITA 2000. So organizations should set up a compliance program which is simultaneously compliant with DPDPA as well as ITA 2000. They should have been compliant with ITA 2000 because that's a 20-year-old law. But no company can today confidently say they are compliant with ITA 2000 because they never considered it as a priority. But now, because of the two laws getting combined, there will be a need to look at both. So this is something which they need to do differently from what they are doing. First, unlearn that if you are GDPR compliant, or if you are ISO 27001 compliant, or if you are ISO 27701 compliant, we are compliant with DPDPA. If they hold that view, that is the first thing they have to shed, and then look at the DPDPA compliance separately, for which they have to seek other means of understanding and application.
Right, right. So earlier you talked about, how critical it is for organizations to understand the implications of this new, act that is going to be coming into place. And since you're also the, chairman of the FDPPI, one thing that, I would like to understand is, what role do you think the FDPPI really needs to play in assisting organizations in securing their privacy and data? How can you help these organizations, and what role exactly are you planning to play?
See, FDPPI is a very unique organization. In fact, the kind of activities we are undertaking, no other organization in India is doing. Why do I confidently say that? It is not only trying to conduct training programs, issue certificates to professionals. Okay, that we do. And in those certification programs, we teach not only DPDPA, we teach ITA 2000, because people have forgotten about ITA 2000. We also try to bring in the requirements of related best practices like the Bureau of Indian Standards, BIS, standard on data governance. So our certification system in terms of the content is completely different, and therefore the people who are trained in our system are, at least in our view, are better equipped. Ultimately, it depends on how the individual will absorb it. Okay, that is one. Secondly, we don't stop at simply creating the certification programs and take pride in saying that we have created so many certified people. We expect to provide kind of service to the organizations to actually implement compliance. For that purpose, we have created an indigenous framework called Digital Governance and Protection Standard of India, DGPSI. In fact, if somebody goes deep into this DGPSI concept, they will understand that what has been created by FDPPI is something phenomenal from the interest of how to make the Indian data protection organizations, say data fiduciaries, self-reliant, at least within the Indian context. They don't have to go to an international organization for certifications. They don't have to pay the heavy price. They can perhaps look at using this DGPSI framework from and use the certified persons from FDPPI who have a C.DPO.DA as their qualification. When I say C.DPO.DA, remember I am also adding the data auditor, certified data protection officer and data auditor. So looking at this, we have decided that we will try to propagate this framework called DGPSI, which includes compliance of DPDPA, compliance of ITA 2000, compliance of BIS standard for personal data governance. So this is a big thing. Now, using this framework, we are trying to create people across the industry with adequate knowledge, so that we are asking every ISO auditor to upgrade himself with this, so that they including all certain auditors, we have said, why don't you become data auditors? So we are trying to provide an opportunity to the existing auditors of different kind who are in the data area to upgrade themselves to understanding the DPDPA as an act and understand this DGPSI as an act. Therefore, we are actually creating something like an end-to-end solution. This DGPSI also is a framework from which we extract an assessment score for an organization on the maturity of their say implementation. We call that as a data trust score. Okay, so once an audit is done, the auditor will say that, okay, you have a reasonable compliance to DPDPA, fine, we give you a check mark. Secondly, we say your DTS is so many percent. Now, which means that he has to improve further. Now, if necessary. So therefore, we have a implementation, audit and assessment framework all rolled into this DGPSI. I think as we go forward, people will realize in the next 5 years or 10 years that this was the biggest contribution which could be made to the data protection community in India. And I am proud that FDPPI has started this activity. We know that it will take its own time, but we are in the right direction, and we hope we will achieve that position in India.
Thank you so much, sir. And wish you the best for the goals that you have set ahead of yourself. Thank you so much for speaking to Team Digital Tech Media and enlightening us on this topic. We had a great conversation with you.
Thank you.